Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with continuing on with the 2020 changes to the GAR contract forms. And today we're going to talk about community association disclosure. So this form has radically undergone many changes for 2020. And the issue is, as real estate agents in a contract, GAR is trying to come up with a form to help disclose all the information from the seller to the buyer, so that there is all the information regarding the fees involved in an HOA and moving into a home where there is an HOA, what those are, so that a buyer may make an informed, consented decision regarding purchasing this home versus another home. Now, the issue, unfortunately, isn't necessarily with the homeowners association in and of itself. For example, it's not your neighbor that's the president or the secretary or the treasurer. The issue seems to be with the management companies that are managing these homeowners associations and the fees they are charging when one person sells a house to another person, and the fees that are incurred for that process regarding the homeowner association, the management company. The other issue is a lot of management companies will only speak with the seller. They won't talk to the listing agent. They won't talk to the buyer. They won't talk to the selling agent. They will only talk to the seller, the owner who lives there. And due to that issue, it is incumbent upon the seller, because they're the only ones that can get the information, to get all the information and disclose it to the buyer. Again, this form isn't necessarily intended as a penalty to the seller. It's just that the seller is the only one that can provide this information. So I'm not going to read through the whole form. In essence, the form has not changed content-wise from how it was in 2019. Basically, any fees that are undisclosed or that change from what was disclosed when the parties go binding will be the seller's responsibility to pay at closing, even if that fee is for a buyer benefit. But they have reformatted some of the paragraphs, changed the language in some of the paragraphs to make it a little more clear, hopefully clear, and to again make sure that sellers are aware that, look, we really need your help in getting the information about what these fees are with respect to the HOA and the management company when you sell the house and a new buyer moves in. So really take a look at this entire form. Read the whole form verbatim from top to bottom. I'm not going to read the whole form to you. I just, for the purposes of this video, want to go over a few of the pertinent changes that you want to look into in depth. The first change they made is a really good change. They shortened the title and made the title Community Association Disclosure. Wonderful. Thank you, GAR. That's what we call it in the field anyway. So thank you. They have shortened the title. Then the next thing that they did is under the type of association. Again, they've had all these different types of associations, but they put it all under one paragraph, so it just makes more sense as you're going through the form and a seller is filling it out. So under types of association, mandatory condo, mandatory HOA, voluntary, master, age restriction, so forth and so on. Those are all check boxes under the same paragraph. Again, that's just a formatting error for clarification. Now, under the fees, where they talk about paragraph 3, information regarding who pays what fees of the association. Under the amounts paid by the seller, in essence, the seller pays any fees required of the HOA or the management company that are necessary for a seller to get a closing letter or a clearance letter in order to sell the property. And they added for 2020 a sentence that says, sellers shall not be reimbursed at closing for any amounts prepaid in order to obtain a closing letter. Then under the section still amounts to be paid by seller, paragraph B, 3B2, fees and special assessments. It talks about any fees in addition to the fees that the seller is required to pay to get that closing letter, any seller move out fees, foreclosure fees, or other fees specifically intended by the association to be paid by the seller are seller's fees. And then here's the first warning to the seller: and any transfer, initiation, and administrative fees and special assessments, as that term is defined below in the exhibit, which the seller does not fully and accurately disclose herein, will be paid by the seller at closing. Now, under the section where it talks about fees paid by the buyer has to pay the transfer, initiation, and administrative fees in order to move into the property and join that homeowners association. But here's the warning to the seller under the section of the amounts to be paid by the buyer. Seller warrants, because again, it's the seller that's initiating this exhibit, so the seller's the one filling out all the information regarding the fees. Seller warrants at closing that buyers shall be required to pay no more than X amount of dollars for all transfer, initiation, and administrative fees. Seller shall pay any amount in excess of this sum, even in the event of any later disclosures made by the seller of increases in such transfer, initiation, and administrative fees. All transfer, initiation, and administrative fees paid by the seller pursuant to this section are considered actual seller fees and are not a seller concession or contribution to the buyer's closing costs. Then the buyer is responsible for their move-in fees, so forth and so on. All right, now the section paragraph 3D, special assessments. To the best of seller's knowledge, there is or is not a special assessment that is owing or has already been approved or has already been raised at a meeting as being under consideration. For all purposes herein, the term under consideration shall mean that a notice of a meeting at which a special assessment will be voted upon has been sent to the members of the association. If a special assessment has been voted upon and rejected by the members of the association, it shall not be deemed under consideration by the association. The seller warrants that the seller has accurately and fully disclosed to the buyer all special assessments that have been passed or are under consideration. This warranty shall survive closing. So this has to do with special assessments that have already been brought up at a homeowners association meeting prior to the buyer and seller going binding, prior to this form being part of a binding contract. And then it has a place, a fill in the blank for the seller to disclose what those fees are. Then there is liability for undisclosed special assessments. With respect to special assessments under consideration or approved before binding agreement date that are either not disclosed or not disclosed accurately by the seller to the buyer, the seller shall be liable and shall reimburse the buyer for that portion of the special assessment that was either not disclosed or not disclosed accurately. Next paragraph, who pays for disclosed special assessments? With respect to the special assessments under consideration or approved prior to the binding agreement date, any fees that come due prior to closing are fees to be paid by the seller. Any fees that would be due that come due after the closing date are fees that will be paid by the buyer. Now, here's a whole new section. Special assessments arising after the binding agreement date. So far, all of those paragraphs have to do with fees and special assessments that have been brought up at a meeting prior to the binding agreement date that the seller must disclose to the buyer. Now, this is what happens if a buyer and a seller go binding on a purchase and sale agreement, and then there's a meeting of the homeowners association, and at that meeting, between binding agreement date and before closing, there are special assessments that are brought up at the meeting. What happens in that situation? Who's responsible for what fees? How does that get worked out? What happens if a buyer is already binding with a seller? There's a new meeting of the homeowners association and there is a special assessment that comes up that gets voted, and the buyer, if the buyer would be required to pay that fee, the buyer might not have purchased this property. So how is that all addressed? Well, GAR is going to address that in the 2020 version of the Community Association Disclosure Exhibit. So here's the paragraph, and it is paragraph 3D3. Special assessments arising after the binding agreement date. With respect to special assessments that are only under consideration after the binding agreement date and are promptly disclosed from the seller to the buyer. A, if the special assessment is adopted and due in whole or in part prior to or on closing, that portion that's due prior to or on closing shall be paid by the seller. B, if the special assessment is adopted and due in whole or in part subsequent to the closing, that portion due subsequent to the closing shall be paid by the buyer. And number 3, notwithstanding the above, if the buyer's portion of the special assessment that is under consideration or approved is X amount of dollars, and it's a fill in the blank for a dollar amount or more, the buyer shall have the right, but not the obligation, to terminate this agreement upon notice to the seller, provided that the buyer terminates the agreement within 5 days of being notified of the above, after which the buyer's right to terminate shall be deemed waived. So in essence, what does all of this mean? It means that a seller that has their house up for sale, where there is a homeowners association and especially a management company managing that homeowners association, needs to be aware of and pay attention to the fees related to the HOA. There are some homeowners that attend the associations, read the minutes, so forth and so on. There are other homeowners that may not necessarily do that. When you are a listing agent working with a seller, you need to let the seller know, bring to the seller's attention that the seller needs to find out what is going on with the homeowners association financially. What are the fees? What are the special assessments? What is under consideration? What is likely to be under consideration? Pay attention to the notices, whether a homeowner gets a notice by mail or by text or by email, or the sign posted at the entrance to a subdivision of when those HOA meetings are. It is really incumbent upon a seller selling a house where the house is in an HOA to understand and know what is going on financially with respect to the HOA and the fees that are incurred by the seller and by a potential buyer moving into that complex or subdivision. So please, please, please read that document verbatim from top to bottom and make sure you have a thorough understanding of what is in there and what must be disclosed, and really go over that with the sellers and buyers. You guys and you buyers agents need to have a discussion with the buyers and the lender to make sure that the fees associated not only with initiation fees and admin fees and transfer fees and moving into the property, as well as regular ongoing fees, how that's going to affect a buyer and a buyer's ability to purchase a property in a subdivision with a homeowners association. There is also a GAR form that I strongly encourage every selling agent to give to a buyer. It is CB16, what to consider when buying a home with a homeowners association. Definitely get that form, that consumer brochure, into the hands of a buyer. So again, a buyer may make an informed consented decision whether or not to buy a home in that is a member of an HOA or another property, and just what is involved with that. Thank you all so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.